Basically, yeah. Yeah, yeah.
Okay.
I call to order
Excellent.
the February 27th, 2024 Township of Long Hill Planning Board meeting. The time is 7:35. Madam Secretary, could you please read the announcements?
Absolutely. Number one, call to order and statement of compliance. Adequate notice of this meeting and hearing has been provided by posting a copy of the public meeting and hearing dates on the municipal bulletin board and website, by sending a copy to the Echo Sentinel newspaper, and by filing a copy with the municipal clerk. Number two, standard board procedures. Any meeting or hearing conducted by the board is a quasi-judicial proceeding. Any questions or comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision, and decorum appropriate to a judicial meeting or hearing must be maintained at all times. Number three, meeting cutoff. Announcement is made as a matter of procedure. It is the intention of the planning board not to continue any matter past 10:30 p.m. at any regular or special meeting or hearing of the board unless a motion is passed by the members then present to extend the meeting or hearing to a later specified cutoff time. Number four, electronic devices. All in attendance are asked to mute cell phones or any electronic devices as to not interrupt with the proceedings. Number five, Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now to the roll call. Deputy Mayor Lavender.
Present.
Committeeman Ray is excused this evening. Ms. Dill?
Present.
Mr. Hans?
Here.
Mr. Malinowski?
Here.
Mr. Opalka?
Here.
Mr. Sandow?
Here.
Vice Chairman Jones?
Present.
Chairman Sandow? Chairman Richardson?
Yes, here.
Freudian slip, sorry. Mr. Chairman Richardson is here, and we have a quorum.
Excellent. Thank you. I wanted to take care of some board business before we got into some of the other business before us this evening. But I understand that we do not have the January 23rd meeting minutes.
Correct.
So we will shelve that till next time for review and approval. So the first item before us this evening is the resolution from Michael Portera, application number 23-11P. And I just wanted to open up for any discussion with regards to your review of that resolution. Hopefully you've all had a chance to review that resolution.
I certainly have one comment, unless anybody else wants to go first.
Please. You've got the floor.
Alex. I was just, on the,
Page 3, paragraph 11. I think I saw a red mark on your...
yeah.
Yeah.
So under findings,
Yes.
we talked about a limitation, days of the week. I don't think I see that in the conditions.
Make sure to
Well, it's
speak
like-
in your microphones,
Yeah.
members.
Wait, so he says,
Patients over 3 nights, and we've spent a lot of time on discussing days of week and when.
right, it's 3 nights per week set. If I recall correctly, the applicant wanted, what was it, Monday, Tuesday, Wednesday?
Whatever nights they
Yeah, I
were.
can't recall exactly what the nights were.
But I think
Is
that's,
there not a
in-
condition of that?
I don't see a condition for it. I didn't notice it, you tell me if I'm.
Right. Further on the site, notify applicants. If that's something the board feels strongly about, we could certainly include that.
Number 11 mentions how many patients per evening, and how many nights per week. Do you mean specifying the specific nights per week? Is that
I was
the
just,
difference?
I was more concerned about the number of days and nights as opposed, and we did talk about Thursday, Friday, maybe Saturday or something like that
Is
towards it.
11 not,
Well, 11 is just a finding. It's not
It's a finding,
condition,
no.
it's just
Oh, I'm sorry.
explaining.
Okay,
No,
okay.
you're okay.
That's my point, it's in the findings, it's something we spent a lot of time, I just don't see it as a condition.
Appointments, further approval is required.
I don't think I see any
Something
conditions.
different. Plans, fees and escrow. Be permitted to work on site. I could certainly go back in the tape. I may have, when I reviewed the tape for it, I do recall that there was conversation about which specific days, so if it's the board's desire, I could go back and include that as a condition as to which days the applicant indicated that he wanted to have this practice open on.
Yeah, days would be good, but
Okay.
if it's more, I just want to make sure it's limited to the number of
As a
nights we
condition,
said.
right.
As a condition.
So is it, do you want to limit it to 3 nights per week, or you want to limit it to those specific days, or both?
I don't mind whatever,
Okay.
I remember us saying latter part of the week, so
Right.
that for me would make more, whatever the discussion
Okay.
was, whatever you find,
Whatever it was that
are.
he's testified to, we'll have the condition reflect that. I can certainly do that.
I think it limited, I think it limited 3 clients coming per evening based on a 45-minute, 1-hour session with a 15-minute
5-minute.
overlap.
To that point, condition number 5, and I do recall that he did,
Yeah,
kind of refreshing my recollection, because it was about a month ago, but he did say that, he indicated that he wanted a cap of 5.
He upped it, we upped it in
Right.
the end.
Okay.
Right.
We did, it was, the discussion was 3 for a long
But it was-
time,
it was-
and then it went to,
Right, in the event, I think he said that some of
5.
his appointments would go about a half an hour instead of an hour.
Yeah.
Right.
Things like that. Okay, so I think my marching orders are to,
Yeah, if we
Go
can
back
make
and
that
clean that up.
adjustment.
right, so a condition, I just want to make sure it's clear. Condition limiting applicant to days operation testified to.
yeah, basically, yeah, whatever
Okay.
findings 11 relate to, would be
So-
good.
Okay, so that being said, we could handle it from this point one of 2 ways. We could defer this to next month and then vote on it then once we see the final language, or you guys could approve it or
Well,
vote on it now.
let's see if there's any other comments or
Okay.
changes
All right, I'll
of
go back-
of
yeah.
significance.
And there may be a reason I didn't include it, and I just can't recall
That's
it
fine,
right now.
that's fine.
So,
That'd be
okay,
good.
so no problem. We'll come back to it next
That's
month.
fine.
Any other input, comments from the review of this document?
I didn't see one more comment
Yeah.
on signs. We had discussion on signs. I know the public spoke about signs, that was a concern.
Actually, I picked up on a conflict because it seemed to indicate there was gonna be a sign, but then there was a stipulation by the applicant that there wasn't gonna be a sign, so,
I think, I wouldn't call it, I think it was more of a representation than a stipulation. I think my understanding,
Okay.
if I recall correctly, was that he had no immediate plans to install a sign, but would like to have reserved the ability to do so at some point in the future.
if we could, Chris, could we just look at the language? It's in number
Sure. Paragraph
4.
Four.
I think, about middle of that paragraph in item 4, it talks about no interior or exterior improvements,
Mhm.
the applicant would be placed,
Oh, may install.
may install an exterior identification sign.
Right. I think that was to be reflective of the fact that he wanted to leave the door open to doing it at some point in the future. But I could just eliminate that clause and just kind of leave it
Okay.
silent as to it.
Well, I just wonder if we should, because I know the public spoke, spoke a lot about signs,
Right.
and I don't see any testimony on the public about concerns around the sign. So I'd certainly like to see a little bit more language about that discussion, because it's an important one to the to the local.
Sure.
Can I
So-
comment on that?
Wait, go ahead, please.
Mr. Portrero seemed to be amenable to the idea that if he was going to have a sign, that'd be a very small sign as opposed to this 4-foot sign.
Correct.
And I don't think it'd be unreasonable to put a restriction
Well,
on that.
to that point, I believe the ordinance limits you to what size of a sign you can have. Liz, do you remember the
Maximum size.
top of your head?
Yeah.
It's max?
4x4.
It's quite big, it's
It's
quite
4
big.
foot by 4.
Is it really?
It's
Yeah.
Really,
quite
for a
big.
home occupation sign? Well, that's pretty sizable.
Well, but that's for,
But he was, you're right, he was keen to the idea of having a smaller sign, and I'm thinking 6 inches by 24 is kind of.
Yeah, 24 is probably, whatever a doctor's
Yeah,
sign
they-
usually
they
is,
hang
if they're a
That
standard
hangs down,
size.
yep,
It's like
maybe 18
21 by
inches.
6 or something like that.
So could we talk,
but that shouldn't be a problem to stipulate that, because the 4x4 is not consistent with a
Right.
residential
correct,
Right.
setting.
If he had stipulated it to it specifically, I would have called it out in here and included it as a condition.
I would go
It
back
may
and
be that
listen
there
to the
was
testimony.
there may have been some discussion about it, but it wasn't like a concrete, clear-cut, I stipulate to this.
All right.
Type of situation.
Just plain devil's advocate.
But that being said, the board can impose whatever conditions, well,
I
unless
like
whatever person
this
wants to.
conversation,
Right.
a bit more clarity than what was discussed before, if it's okay to go with, as you said,
Mhm.
some sort of more reasonable limitations.
5.5 feet,
And
right?
that's if he chooses to
Yeah.
put up a
Mark.
sign. He may not even wish to
Right.
do that.
Right.
So,
so presuming that there's no clear-cut dimensions in the testimony, what would the board feel would be a reasonable restriction on the size of a sign?
I'm looking that up.
6 by 24?
18 by
6.
10 or something,
Maximum.
whatever.
18,
I'm just making it up a little bit.
I heard 18
6
by,
might be a little too.
yeah, 6 is a little
10,
compact.
10, I
by-
think, 10 is
10 by
better.
24
10 by 24.
inches.
10 by 24.
No,
Okay.
10,
Go ahead.
No? Too big?
I actually made one of these for my father.
Oh, you did? Oh, okay.
8 by 24.
Perfect.
Okay,
All right,
perfect.
done.
All right.
Okay.
Sold.
Done.
Sold.
24. Okay. Okay, and I think all those would be,
Great.
as far as the law is concerned, reasonable conditions to impose. So I
Thank
will,
you for that.
have an amended draft for you guys at the next meeting.
Any other feedback on this resolution?
I think 2 of us are not eligible to vote on it.
Well, I personally would like to see,
Yeah, yeah, oh, yeah, absolutely. Yeah.
Yeah.
Well, as long as that's the board's desire, unless there's a,
Yeah, no, there's a consensus
I'm hearing
amongst
otherwise,
the
but
board.
we'll defer to the next meeting to, once all the language is included, I think
Right.
that's,
would you mind, I just want to be clear, and maybe
Yeah.
give the applicant an opportunity to review as well, perhaps.
okay, yeah, we can try to arrange something in that regard.
I thought it'd be
Yeah.
an agreeable thing, then.
Typically, we don't circulate these to applicants ahead of time unless they're represented by counsel, but I don't see any reason why. we couldn't.
However you want to
Yeah,
handle it,
yeah.
it's
Well-
just a suggestion.
Okay. I can, I'll see what I can do.
So what I'd like to propose is that you'll make these adjustments and we'll look at them, slate it for the next meeting.
Absolutely, Mr. Chairman.
Thank you.
Perfect, thank you.
All right, moving right along,
problem.
into applications. The first is an extension request for blocks 12301 and 10100, lots 1 and 7.01, zone LI, I, MU-0 at 50 Division Avenue. Are there any comments to that particular extension request?
I've got
Yes.
about 4 questions, and they're probably very basic questions. So my first one is, why are these extensions being requested? What's
This,
the purpose of
this
it?
particular applicant was, as a condition of their approval, they needed to get a letter of interpretation, LOI, from the DEP. And they've been in the process of trying to obtain that, and they still have yet to hear back. And the MLUL permits extensions when an applicant, makes a diligent effort to get outside agency approvals, and they can't get anywhere. The law kind of assumes, but it makes room for the fact that government agencies kind of take their sweet old time sometimes, so.
So they're dependent on a government agency to complete a process, but
Correct.
they're up against an end date where they need to extend past that.
Correct,
So that's the rationale for asking for the extension.
correct, sir.
Okay? Are there any changes to the resolution,
No changes to the resolution that I'm
to the
aware of.
original resolution with this extension? being
No,
requested?
if you, actually, I think on the final paragraph, it should say, the last clause. I'll just read the whole thing. With such extension to be subject to all the same conditions that are set forth in the resolution of approval, to the same, to this extent same is not inconsistent with this. So,
Okay.
yes.
Okay,
Well, everything's
thank you.
still fine, yes.
I'm asking that for due diligence.
Yeah, no, absolutely.
These next two kind of bucket together.
Okay.
What happens if this resolution doesn't pass? What are the implications should this resolution not pass?
If this doesn't pass, well, their approvals would lapse and they wouldn't be able to obtain permits.
So then they wouldn't be able to move
They'd
forward.
essentially be back at square one,
Okay,
Right.
and then they would have to come back and do the whole, okay.
presumably.
What I wanted to understand, what's the
I
ramifications?
mean, unless, well, that's if they don't sue you and take you to court and then we can get involved in
Okay, so that
litigation.
opens up litigation
Right,
and so
potentially,
forth. Okay,
potentially, right.
no,
And if correct me if I'm wrong, but part
Please.
of the reason too
Right.
is that they're asking for the extensions is because the moratorium on the sewer.
correct. They're dependent
That's
on
correct.
New Jersey American Water.
Is that stated in the resolution, though?
No, that's, I believe, the other one, Prison Millington.
No, PRISM.
No, that's the one we're referring to.
Yeah.
Oh, I'm sorry,
I
I
gotta
got them out
say
of
which-
order, my
yeah.
apologies.
That's
Oh my God, I'm so
Aren't you glad I
sorry.
asked
Thank
these
you.
questions?
Thank you.
Yeah, good thing.
Yeah.
But everything I said still applied,
Okay.
except for what that might my apologies.
That's
I hadn't,
That's
See,
fine.
I don't know, did prison need an LOI? I'm not sure.
No, Prism need is the sewer, which is a similar situation. They're
Right.
need an outside agency to kind of get off their butt and move so that they can continue with their project.
Mm-hmm.
G2 is the one where they need the LOI.
Okay.
You know, essentially, it's the same sort of circumstance, legally speaking.
Different entity.
Right, but,
Okay.
similar. Right, exactly.
By my recollection, this is the second time they've had an extension,
No.
correct?
That's correct.
So
there's
do
a good
they-
chance of coming
for
back for a
Prism?
third.
Yeah. They
Do they
came in last
technically
year.
need,
Yes, Prism, this is would be their second extension.
And do they make note of that?
I did make note of that. In
Oh, you did?
paragraph,
Okay, fine,
um,
fine. So this could continue, I'm sorry to interrupt. This
No.
can continue,
You
Right.
get three extensions, right?
so there is a
Actually, no,
limit.
I'm asking as if I
Yeah,
don't know.
yes, you did.
Yes, you get three, you
Okay,
can apply for up to 3 extensions.
okay.
All right. These are, but it's 1 year
Correct, 1 year
for
per.
three,
Right,
right.
right. So if they
Okay.
want the third one, they'll come back, you know, February of 2025 and potentially request.
So what
Yes,
happens
Tony.
February of '25, sewer still isn't in place? Do they start over, or,
No, they can request one more extension.
so
in
let's say
25,
February of
26,
'26, it's not done then, right?
Um,
So what happens at that point? I think it needs to kind of be explained here that,
Right. Well, like we were saying before, that presumably their approvals would expire and they wouldn't be able to
Have to reapply.
continue with the project. They'd have to basically start from square one. That being said, there might be some legal research and some case law that I'm not aware of. At least right now, I'd have to maybe dig into it because frankly, I've never come across a situation where that's happened.
okay,
I'm sure it has happened. There must at some point in the future, but so I could get you a little more research on that.
so instead of doing this every year, is it possible to make the resolution that until they have the right, until the sewer is available, rather than doing 1-year extensions per?
I don't believe so. I think by operation of how the statute is worded, you can only apply for 3 1-year extensions, and that's how it's
Yep.
spelled out, right? Then that being said, I guess theoretically they could request multiple extensions at once. I mean, I don't know. It's
Because the question,
No, that's
because
not
the reason, because if you let it lapse,
right,
you open yourself up to litigation,
correct,
is what, right? So,
potentially.
is there a way for the board to protect itself from potential litigation by putting something inside this resolution? Some wording inside that makes it so that as long as that is the last step that they need to do, it's still valid.
Or
But if
are
they're
we
thinking,
already protected?
Yeah,
Or
I think,
are we
I
already
think we're
protected?
all right. We should already be
Yeah.
protected. Yes.
so if the third one expires, right?
Right.
Yep.
And it's a fault of not a fault, but it's on behalf of somebody else, American Water perhaps, for the sewer.
correct.
The town, I would think, is
Right.
clear and,
I think we're getting into some academic discussions here.
Yeah, but it's
so,
interesting
Mr.
to
Sanders,
see-
do you have-
Definitely.
just
Right.
to,
Would you like
It's
to?
a good
ref-
question. It's definitely
Yeah.
worth. If you want, I could absolutely look into it a little bit deeper if you'd like.
Do we know that the applicant has in fact completed all the changes required in the drawings by the resolution, so that those drawings have in fact been signed off or not signed off by the board?
No.
Or
They
is
have
that
not
still pending?
They have not begun their resolution compliance documents yet.
So we're still sitting on the original drawings, waiting for them to be corrected. And here we are on the second extension. Thank you.
Okay, any other comments on this particular extension request? Is there a motion to approve?
So moved?
a second.
And to be clear, this is for Prism Millington, correct?
Prism, yeah.
This is for 50 Division Avenue.
Yeah.
All right.
Okay. Vice Chairman Jones?
Yes.
Mr. Hand?
Yes.
Deputy Mayor Lavender?
Yes.
Ms. Dill?
Sorry, can I vote?
You can. On extensions, you can. Mr. Malinowski?
Yes.
Mr. Opalka?
Yes.
Mr. Sandow?
Yes.
Chairman Richardson?
And same question Teresa has, since I recused
Oh,
myself
yeah,
from
you
the
can-
application.
you have to recuse.
Right, so I'll have to abstain or
Yeah.
recuse. Okay.
Well, I think you've recused in the past, so we'll put
Right.
you as recused.
Yep.
Okay. So needless to say, the motion carries.
Dom, before we move to the next one, I'm sorry
Yes.
to go back to it.
Sure.
For the resolution, can we just add to the to-do list? I think,
For the Portera resolution?
yeah, I
Yes.
think
We slide
that
back
we
to it.
all agreed that it should be loaned to like an acupuncturist. Did
Yeah.
Yeah.
that in here?
Yes,
Pretty
if I
sure
recall
we-
correctly, condition number,
That,
if number 6, page 8, the board shall retain jurisdiction and further site plan approval shall be required if another home office use on the
perfect.
property.
Okay,
Yeah,
gotcha. Thank you.
right, I got you, no problem.
okay, thanks. All right, the next extension request is for block 13509, lot 17 and 38 in zone R4 at 17 and 23 Gates Avenue. This is under application number 21-26P. Any discussion? Yes, Mr. Sando.
Do we have the letter from the applicant's attorney requesting this extension?
Yes.
I think, do I have a copy of it with me?
I
Present.
haven't seen it.
I believe, Fred, you submitted the letter.
I did.
Yes, please.
Speak to
Not
it.
the attorney.
Yeah. Here.
Okay.
Produce a letter.
Are you looking for it, Counselor, or do you know if you have it or don't have it?
I'm looking through my file right now.
I
My
have it on-
question is fairly straightforward, and that is, does a letter from the attorney spell the applicant's name correctly? Or is this resolution that we're about to consider introduce a spelling error that the attorney did not introduce?
I have no idea.
And
Did I spell Mr. Velez's name wrong? Is that what you're telling me?
somebody spelled it wrong, and neither you nor our attorney nor our secretary chose to correct it before we put it on the agenda.
Then I hereby amend it to the correct spelling of Mr. Velez's name, if I in fact misspelled it.
His name is spelled Verlazza.
E-Z-Z-A.
EZZA.
Did I
So
have
it's
an A?
spelled correctly
A's.
on the agenda,
It's 8, okay.
Where is it spelled incorrectly? On the resolution?
On the resolution.
on the
extension?
resolution.
Okay.
That is my mistake, my apologies.
Hmm.
I think I may have used the original resolution. Hopefully that one doesn't have the incorrect spelling too, but that probably would have.
Boy, I hope that one has.
His name doesn't come up in spell checker.
3 sets of eyes didn't catch it.
Any other comments on this particular resolution? One comment that I quickly had is since demolition has taken place on that site, I know there, Joe, was a lot of discussion with regards to a berm that was gonna be put in place to deal with stormwater runoff. So, because we're kind of in this interim period, is there anything that can be done? I'm concerned as I walk by that property that drainage has been affected and site plan improvements have not been made as part of this application. So is there anything that can be done in the interim? I'm more asking that as a question. Any jurisdiction?
I was your board engineer at the time of your vote. The application was continued with your prior engineer.
Right.
I can tell you that I'm familiar with the property because the resolution compliance has been submitted.
Use the microphone, please.
The resolution compliance has been submitted a couple weeks ago. That's on my desk to review. And with this extension, as our attorney mentioned, it's related to the LOI. They're still awaiting. The demo permit was pulled separate than the improvements or the approval. So I think it would just be merely a request of the applicant to address some stabilization in any of the areas around the demolition.
Okay.
You would think, as part of the demolition process, that those concerns would be taken into account.
Yeah, and again, I'm not suggesting there's a problem.
Yeah.
I'm just saying we're
That
in this
there has been
interim.
disturbance and there
Right.
is
Yeah.
not a permit to construct.
Correct.
Yes.
And I do know and recall very clearly that application had
Yeah.
stipulated some drainage improvements. Yes, Mr. Sando?
Do we know if the deeds and plats have been filed for the subdivision itself?
Fred? Fred,
That worked.
There you go.
That worked.
Have a seat.
let's go put this one down there anyway.
You're comfortable.
Yeah.
Make yourself comfortable.
You don't have to go, you don't have to go too far anyway.
Just,
Gonna use this one in my hand.
Got lots of mics now.
The subdivision deed has been signed by the board and by the applicant and has been recorded with the county.
okay. I ask that because I understand the two lots are for sale individually, and therefore, if one of them sold but not both, you'd need the subdivision deeds in place before the sale could be made, and that you say that has been done.
You are correct, and it has been done.
Now, does the filing of the deeds, this is a question for our attorney, does the filing of the deeds and the demolition count as starting work so that this extension is not required?
Are
No.
you? No.
I'm sorry, say that again. Your response was no to?
I was going to potentially, I don't know the extent of demolition, but it could theoretically, demolition, Fred, do you?
I'm working off of memory, but if I recall correctly, the actual condition that we're worried about
Right.
is pulling of permits.
Okay, okay,
Or, yeah,
okay.
so we're not in a
So the
position to do
context is
that.
just this application, I see.
Right.
Okay, yeah.
Okay.
So-
Any other comments on this?
Well,
particular
I
extension
just would
request?
like to make sure that any demolition hasn't negatively impacted the property in a way that runoff water now potentially goes where it shouldn't or could be avoided, so.
Well, I mean, certainly if it turns out there's a practical issue with drainage or something as a result of it, certainly bring that to our attention.
Okay.
I think you might know where to find Mr. Velez.
So that's something we have to come to you as opposed to whoever took the, I haven't looked at the property for a while.
I mean, I agree with your engineer that if we haven't been required officially to have done it yet, there's not an enforcement issue, but it certainly makes sense as a practical matter. We want to be good neighbors like anyone else.
And my only concern is because it's extended for another year, so that could be a year that it just sits there.
The owner in a situation like this has every motivation to get it done as quickly as possible, so.
I think we would have also heard from the residents that would have been impacted. I've not heard from the residents,
I don't think,
but I might get a
I
phone
don't
call
think we,
tonight.
we would have done, all I'm asking for in good conscience.
Yes.
Just to double check to make sure it looks, if everything's okay, fantastic.
You can drop
I
by
hate if
tonight.
it sit there and we get a storm and something negatively happens where we could prevent it ahead of time.
Understood.
That's all I'm asking.
Good.
So I'll set into the resolution.
Good. Any other comments on this resolution? If not, I'd like to hear a motion to accept this extension request.
So moved with the corrected spelling.
So just to be clear, VERLEZZA?
Correct.
Okay, I'll make sure a corrected draft gets to Deb before.
Thank
Good.
you.
things
Is
published.
there a second?
I'll second it
Thank you.
Okay.
with the correct spelling.
Vice Chairman Jones,
Yes.
Mr. Sandow,
Yes.
Deputy Mayor Lavender.
I believe I have to recuse myself.
Oh, that's right, you do, yes. Ms. Still,
Yes.
Mr. Hans,
Yes.
Mr. Malinowski,
Yes.
Mr. Algalka,
Yes.
Chairman Richardson.
Yes.
Motion carries.
Very good.
Thank you all.
Great.
Thank you.
Thanks.
Be right back.
Very good.
Okay, next is a application for a minor subdivision lot line adjustment for block 12806, lots 21 and 6.02 in zone R-2 at the address of 57 Dogwood Terrace and 66 Carlton Road. Application number 23-10P.
Mr. Chairman, while applicant's counsel is getting ready, I would just point out for the record, I did have an opportunity to review the applicant's notice. I found both the content and timeliness of service of such notice to be sufficient. Members of the board may recall that this was originally scheduled for the board's February 13th, 2024 meeting, but the applicant had to renotice because we had to cancel that meeting due to the snow. Anyway, for the current notice for tonight's application, or tonight's hearing, I'm sorry, the notice was sent to owners of property within 200 feet of the subject properties on February 15th, 2024, and also published in the Star Ledger on February 16th, 2024, both more than 10 days in advance of tonight's hearing, and thus, in my legal opinion, the board has jurisdiction over this case. So that's my spiel. Thank you very much.
Great. Thank you. Please, the floor is yours.
Good evening again. Frederick Zelli, Post Pollock, on behalf of the applicants, Jaime Colon and Carolyn Benabi. First, I want to apologize on behalf of Mr. Colon. He had every intention of being here this evening, found himself in Boston on business and not able to get back in time. I will candidly tell you, though, if he were sitting next to me, I was intending to place him under oath and not ask him a single question, unless you had him, because I had one for him. Mr. Hollows is going to explain this extremely straightforward minor subdivision application. We are not creating any new lots. We are taking one of the more bizarrely shaped backyard lines I've ever seen in my life and making it make some sense for both property owners. The rear property owners, of course, the Doyles, have consented to this application. And effectively, we are not changing the overall areas of the lots, only to a very minor degree. And again, it squares off the Colon Benabi property so that their backyard is more of a traditional area. It gives them some space between the rear line and their pool, and has no practical effect whatsoever on the neighborhood or any adjacent property owner. The only thing I want to represent, I have spoken with Mr. Colon about the issue raised by your professionals, which is a storage shed that is straddling the line now. Obviously, the neighbor's, it's a neighbor's shed, it's not ours. They obviously should have complied with the setback. If the board has an issue with that, our position would be that it's an enforcement issue, not really something that would be dealt with here. And again, it's not my client's shed, so we have limited ability to do anything about it anyway, other than make a fuss with our neighbors, which isn't something you particularly like to do. So if the board does have an issue, we respectfully request that it be handled through your zoning officer so that we're not making friends with our neighbors. Other than that, I have one witness this evening, Mr. Hollows, who will explain the application. There is one form of relief that we need aside from the minor subdivision itself, which is relief from a condition from a 1994 resolution which subdivided and created these lots in the first place. That was a restriction against further subdivision. This technically violates that, and therefore we need relief from that clause. I don't think there's any question, though, that the purpose of that restriction was to keep an additional lot from being created, which this is not doing. We are simply adjusting the line between the two lots in question. So aside from that, and of course the subdivision itself, we need no relief. There's no variances or anything in this application.
Great, thank
If you
you.
have questions for me, I'll call Mr. Hollows.
Do you have any questions for Mr. Zelli at this point? Or can we move on with the,
Just Mr. Hollows is testifying to this
That's
evening? Okay, great. All right, I'll get him sworn and qualified when he's ready. I'll get our board professionals too. If you guys could all please raise your right hands. Do all of you swear or affirm that the testimony you're about to provide is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Great, thank you very much. And Mr. Zelli, before Mr. Hollows gets started, quick question. Everything that he's going to be presenting tonight, do we need to enter any exhibits or it's all plans?
There will be one exhibit.
Okay, one exhibit. And you'll call that out when it comes up? And
Yes.
okay. I hate to derail you, Mr. Hollows. I do that quite often. I don't want-
Since you've asked that question, I
Okay,
will raise
testimony.
one thing. Ms. Coons was able to find decent copies of the 1994 resolution. We did not. We had a horrible copy. We submitted it as best we could.
Mhm.
I don't know if you want that formally marked as an exhibit. We can do that.
I think that would be
Yeah,
appropriate.
out of
Why don't
abundance
we
of
make
caution.
that A1 and then Mr. Hollow's exhibit will be A2.
Resolution. Okay, and I'm sure I'll get a copy of that at some point to look at, Mr. Zelli, but do you know the date of that offhand, when that
It
origin,
is,
date of adoption?
yep, December 6,
Bill,
1994.
Bill, take the mic with you, please. Take the microphone with you.
What I will do, I will pass out,
Pass it down the line.
hand it to the chair, and this is A1.
Great.
I don't think we have the exact number, but apologies.
Yeah, I'll send them out. So, yeah, what do you- yeah, so it's-
Have to share.
I'll mark this A1 just to be safe. Okay.
So, just one question for the attorney. So, this, I'm just glancing at it for the first time.
Sure.
I see a reference to Carlton Road. Is that because that's a landlocked piece there? That big square spot?
Mr. Zelli, could you
What I'll do,
Hi, Mrs. Doyle. Hi.
please,
Help her find the door to come in.
I-
So that's a property lock
well,
flag
Mr.
stack.
Hollows will go through and
Okay,
lay
good.
the
All
land.
right.
as
because-
I'd have to have her
Thank you
sworn
very
in, yeah, just,
Thank you very
yeah,
much.
no, all good.
I'll stay quiet.
Okay, please proceed.
One of the paper street examples.
Yeah, I know this.
Okay,
If we,
Mr. Hollows, just for the record, you've been
right.
qualified as an expert in professional engineering by this board in the past, is that correct?
that's correct.
And your license is still in good standing this evening?
It is.
Mr. Chair, do you qualify, Mr. Hollows?
Yes.
Thank you.
Any,
No objections.
anybody objects? Please proceed, thank you.
Bill, would you start by showing us all of the lots in question and?
Yeah, Dogwood, 57 Dogwood Terrace is the property owned by Mr. Cologne, and he's the applicant for this.
Hold on, time out, guys. Hold on. Mr. Dennis. Please, thank you.
57 Dogwood Terrace is a property owned by Mr. Cologne. It's known as Lot 21, Block 12806. It is the big subject of this property, of this application. And Lot 6.02 has an access from Carlton Road. It is a flag lot that was subdivided in 1994. 30 years ago, and it's vacant. At that time, it was approved for the subdivision. There was a typical house shown, et cetera, for that application. And what we're proposing to do, something rather simple. You can just see how the Cologne property is just cut off kind of oddly. And this would be A2. And what I've done here is just side by side. This is, on the left side is existing conditions drawing. On the right side is proposed lot line change, basically. But we have colored it so that you can see what the oddity is of this property, that the property line is really close to the swimming pool. And then you got really something that's unusable in this triangle down to the south.
Mr. Hollows, I hate to interject. Could we just get a date for the exhibit, please?
It's the same date as your drawings,
Okay, great. So that would be,
July 31st, 2023.
okay, great. Thank you very much. And we'll call that, like you said, A2, colorized existing versus proposed conditions exhibit.
Yes,
Sound good?
sounds
Okay,
good.
great, thank you.
And what we're proposing is to kind of make this squared off. We've got Dogwood Terrace on the top, and then we've used this point, which is our, southeasterly property corner, and kind of use that as a pivot point to come up with the new property line, which is just about parallel to Dogwood Terrace. And then it was almost equal properties. We have the Doyle property will end up with 47 square feet more than the Cologne property when we're done with this. Other than that, there are no bulk variances required, other than we've got that shed that's over the line by the neighbor. And you can see pretty obviously that this makes the rear yard a lot better than the way it is right now. I can give you what the new lot areas will be. It's 56,058 square feet for the Cologne lot, and the Doyle lot will be 2.55 acres on the vacant lot, which is a wooded vacant lot.
And so the Doyle lot is going to increase by 47 square feet, and the Cologne Benabi lot is going to decrease by that amount? Is that
That's correct.
accurate? And can you show the board again how lot 6.02 is accessed to Carlton Road?
There is a staff that comes in from Carlton Road, comes into 6.02 6.01, and then there's an easement across 6.01 to get to 6.02. That was part of that subdivision that was done 30 years ago.
And just to make it clear, and so I don't have to put Ms. Doyle under oath, 6.01 is the Doyle's residence where they're actually living. There is a house, is that correct?
That's correct. There's a house garage there.
And just so the board understands, they own both of the properties. So 6.02 is in question here, vacant land, and they own the adjacent property, 6.01. Also, just a housekeeping matter, the photographs, since I don't have my client to authenticate them, photographs submitted were taken by myself shortly before the application was filed. They accurately represent what was seen at the time they were taken.
So
Actually,
what's- Sorry, just ask, the applicant's Jamie Colon,
Jaime Colon and Carolyn Benabi, yes.
so what's their relationship to these properties then? If Mrs. Doyle's own it?
They own 57
They own
and live at 57.
the other people on 601. So,
Good.
Yeah.
Does that complete your?
I have nothing
initial comments?
further for Mr. Hollows. This is about as straightforward as it can be.
We
No,
will
which is
open it
okay.
up to board
Are these
professionals.
used?
Ms.
Yeah.
Lehaney, would you
Yeah, thank you.
like to take the floor and ask
Sure,
any questions?
Mr.
please?
Chair. I'll just go through my letter, which is dated February 9th, 2024. The first comment I had is regarding getting a copy of the resolution, which was provided. And I just wanted to understand if there were any conditions, aside from the ones that the applicant mentioned, relating to, that might shed light on anything having to do with this application. And it doesn't appear that there is anything in that resolution. And that resolution created 6.02 from 6, I think, right? So it
Correct.
was one large lot, and that makes sense. You can see that it's quite regularly shaped. And they had to make it 6 and 6.02 because 6.01 already existed on that weird-looking street, 6.01. But the next question I had, and perhaps nobody knows, but is, and I was hoping that maybe the resolution explained why it was so jagged to begin with.
Well, the 57 Dogwood Terrace, or the lots on Dogwood Terrace that go out to Carlton Road, are on a Skyline Ridge Section 4 subdivision, and there's actually 3 of these types, this being the much worse than any of the others, but, where the lot line kind of gets into it. 'Cause it seems like the lots are a little more square
Right.
to the south, and then you've got the road that went in,
Okay.
and it kind of curves around as it goes over to Carlton.
Okay, and then the third question I had is regarding the shed, which straddles the lot line between the applicant's property and apparently their neighbor, who's not subject to this application, and it's the neighbor's shed. So I guess that's really up to the board as to however you want to handle that. And I had said that they should seek a C bulk variance. I don't know if it's appropriate here because they don't own it. So, but that was the extent of my comments in my letter.
Okay, thank you. Joe, did you have any comments?
Just one on your testimony, you had noted that the rear lot line adjustment is near parallel to
Well,
Dogwood
yeah,
Terrace,
it's
and-
not, I realize it's not parallel because we basically
Right.
pinned the lot line on this corner and then swung it to get just
Right.
about equal
So
properties.
utilizing that corner, and then if you were to make it parallel, there would be a greater land swap than what's proposed. So it's a balancing.
Yeah, I mean, the only way you could make it parallel is if you did something different like this.
And that would take more from the subject property and would be a
Potentially.
larger balancing than the small square footage. So I have no issue with it. I just wanted to point it out for the board. That's the reason for it, and I think it's appropriate the way it was proposed. And then one thing I just picked up that is not in my letter, there's reference to lot 6 represented as 6.01 and some typos on the plan set.
Okay,
So just as a point of revision in when you revise to file
Sure.
for compliance.
yeah, and if the board were to approve this would be perfected by filing deeds.
Good, thank you. All right, before yes, well, I'm gonna open it up to the board, so please ask questions of the applicant or the professionals.
I'd like to address Ms. Lehaney's comments. The question about, the jaggedness of all of this is based on the fact that when Joe Sincata bought the properties, the Semarat and the Thompson properties, in order to build the Skyline development, he was constrained by the fact that Lot 6, which is the predecessor of Lot 6 plus 6.02, Lot 6 existed, and it jutted into the properties that he was able to acquire. And then he began to lay out the development, and he had already built Skyline Drive parallel to Carlton, decided that the additional streets had to not be orthogonal, and so Dogwood tends to curve around. And then, having laid out the streets, he began to get individual lots of the required size of 45,000 square feet. And the result was that this particular lot had to wrap around that corner, and they weren't very smart about adjusting the street or adjusting the lot lines, and they just left it that way because it mapped clean and all the lots were the right size. And that happened in 1972, thank you. And apparently, there was no attempt by Sincata to buy out that little corner piece of Lot 6. And there was no need to, and obviously the subdivision was approved as it stands, and it's now taken 30 years, 50 years to do something that's rational.
Great.
With regard to whether or not we learn anything from the old resolution about Lot 6.01, the answer is no. The resolution reads that Board Member Donat, who also happened to be the town tax collector at the time, she observed in the resolution that that strange little piece of vacant street was strangely already marked as 6.01, and she did not understand why as of 1994. Now, I have found that same notation on the 1959 tax map, and so that strange little dogleg vacant street, Lot 6.01, is lost somewhere in history before 1959. And
Thank
is
you- thank
probably
you.
irrelevant because it doesn't touch upon these lots anyway.
No, thank you for that. That's very helpful from the historical perspective. Do we have any questions coming back to the application?
I just, the only reason I brought it up, sorry, was
Yeah.
because when you read the resolution, it talks about 6 and 6.01,
Yes.
and it's confusing because a condition of the resolution is you have to change 6.01 to 6.02. So just if anybody reads the resolution, that's why it's a
Good.
tidbit
Good.
confusing.
Okay, thank you.
Yeah.
Any questions, board, for the applicant or the board professionals?
Mr. Chairman, I have a couple. Mr. Zelli, probably questions for you. Is the applicant stipulating to, or are the applicants stipulating to all the conditions in Ms. Lehaney's memo and Mr. Voich's memo?
Yes.
Okay, great. And, well,
Other
with the
th-
exception of the removal of the
except
shed.
the shed, right.
Right, I got you. Yeah, I think Mr. Voich's were all just basically plan revisions for the most part, submitting a
Right.
CAD and PDF. Okay, so understand that. Additionally, as it relates to the request for a modification of that condition, I just want to be clear what's being requested. Are you requesting to excise that condition completely, or just to modify it to the extent necessary to permit this subdivision that's being proposed?
That's perfectly fine. We're not looking for anything that would lead to approval of creating another building lot, which
Okay.
we're sure is the intention of that in the first place.
Okay, great. Okay, just wanted to make sure we're all on the same page. Great. Thank you, Mr. Zelli. That's all I have, Mr.
Just
Chairman.
to preserve the record,
Sure.
and I might have missed it, did we open it to the public?
In a minute.
Okay.
I just wanted to get,
Perfect.
I wanted to get the board questions first, and we'll open it to public. Yes, Mr.
I
Sanders?
have two questions for our engineer. You state that the application should be sent to the Morris County Planning Board.
That has since been
It is my
provided for
understanding that the Morris County Board only requires property or developments which are on a county road or within 200 feet of a waterway to go to the Morris County Board. They don't care about anything else. They leave that to the towns. Am I incorrect in that? Or do you know something that I don't know about what the Morris County Planning Board requires?
I can answer that because the Morris County Planning Board has told me specifically that by their rules, any subdivision application, regardless of whether it touches on any county facility or county road, must be submitted. We have submitted it, and they've issued a letter of exemption, which I did supply to the board, so we're covered on that.
And
Thank
that-
you.
That was my understanding, so that's why I put it in the letter.
Well, that's one condition of approval we can remove.
We need to find out why the county is making rules that are stricter than the statute permits.
Okay, any other questions?
Yes,
this along.
yes,
Yeah,
yes,
another one.
bear with me. I want to ask about, 3.4 in your, where you talk about going back to the original subdivision plat.
3.4?
3.4.
3.4 is just clerical cleanliness of the Recordation Act and notation on the plan. So it's just a recommended statement I provide for all minor and major subdivisions. This is gonna be filed by deed, but on the plot itself, it just cleans up the record between the professionals for the purpose of recordation.
Well, you're quoting here that the boundary map for the original 1972 subdivision has to be updated.
No, this is the citation in NJAC that in all instances, including where deeds are used to record minor subdivisions in this case, that the licensee who prepared the boundary map on which the subdivision is based may provide the certification on subdivision plat. So essentially the certification that's provided on the top of page 3 is that Mr. Hollows is the signator on the survey that he submitted, as well as then on the proposed subdivision. So it ties the two together.
Is that all clear to you, Bill?
Yes, yes.
Thank you. Thank you, Mr. Chairman.
Thank you. Any other questions?
I just have we don't often have dual applicants like this, from what I recall. I just want to make sure you're all good, the applicant's all good with what's being.
They can come up during public comment. We haven't opened it up to the public if they'd
I
like
was
to
just asking
speak.
that.
And they did, the adjacent property owners did consent to the application, right, Mr. Zelli?
Yeah, I just want to make sure everybody's good.
Right.
And here's my real flippant comment. Bear with me a second. So if you just did a semicircle around the shed for about 12 feet and move it to the other no, I'm kidding.
How does it go on there?
Yeah.
Okay.
And 40 years from now, they'll say, why did you
Why
do
is the
that?"
semicircle around there?
Yeah. Oh, I see what you're saying, subdivide off the shed and.
Yeah.
If no other questions or comments, I'd like to open it up to the public. If anybody from the public would like to speak to and ask questions of the specific testimony that's been presented.
Questions and comments, Mr. Chairman?
Question and comments?
Question
Correct.
and comments.
Please, come on up.
Please speak into the,
Please.
Miss,
Whoa. Come out.
when did you, yeah, gotta pick up.
Hi.
Name and address, please.
Hi, Rochelle Welt, 81 Dogwood Terrace, a few houses down from that lot.
Okay.
My question is, do they plan to build on that lot now that it's subdivided more equally? And if so, I'm interested in understanding that better, and of course, that would affect my property because we are at the lowest level on that street.
I am not able to address that. Ms. Doyle is here, but I think that would kind of unfairly put her on the spot.
Okay.
Okay. But then I'm going to have to ask you to come forward, though, and be sworn in.
We don't bite.
Ms.
Let-
Doyle.
Let them swear you in first. Let them swear you in first.
Subdivision
Ms.
is
Doyle.
Hold on.
Time out.
Let them swear you in.
I'm
first.
sorry. You gotta swear. Do you, no, keep it up, keep it up. Do you swear or affirm that the testimony you're about to provide is the truth, whole truth, nothing but the truth, so help you God? Thank you. And name and address for the record, please. I'm sorry to do this, but
Ann
it's.
Doyle, 64 Carlton Road.
Thank you.
The subdivision is technically not in place because when we bought the property from the previous owner, he was in the process of getting that, and he actually kind of misled us. He told us that he had already gotten the subdivision. But we have never really completed the subdivision because there was, they told us that we would have to pave the driveway and extend it into that other lot. And we've never done that, and we have no intention of ever doing that as long as we're there.
Mr. Hollows is shaking his head vigorously, so.
What?
In 1994, Murphy and Hollows Associates did the subdivision.
Ah, now it's
And-
adding up.
To my knowledge, reviewing that file, everything was done that was on that resolution in 1994. There was no paving of the road. Maybe,
Told us we had to extend that road and pave it and widen it, but they gave us a easement.
well, obviously, we couldn't do any construction, but I mean, as far as the plans for that subdivision, it was complete. And,
Certified of the survey that identifies the lot as existing?
yes.
Yeah.
And this is this is from the tax map, correct? These drawings, so they wouldn't draw that other lot if there wasn't a lot created, correct?
In fact, there are deeds for that, for both,
Right,
for the
right.
individual lots.
Right.
Legally, it was perfected. I don't think there's any
Yeah.
question.
Okay. Nevertheless, and maybe this is, I don't want to get ahead of you, Fred, but as you mentioned before, I asked you if you wanted to modify that condition to permit any development on the 6.01 or any further subdivision,
That
which is not going to happen.
that restriction does
Right.
not prohibit development of 602.
Oh, that's true.
That
Okay.
subdivision contemplated development of 602. What that deed restriction prohibited is
Further subdivision.
dividing sub 602 or 601 or whichever.
I see.
We all get them confused at this point. 6 or 602 into yet another building lot. That's what that's precluding.
Okay, okay, all right, just wanted to be clear. Okay, my apologies.
And I think it's fair to say we do not have an application before us to do any building on that other lot.
The vacant lot, no.
Right.
But just to be clear, because I don't want us to mislead you as a resident either, the Doyles, as the owner of that lot, unless they were to want to construct something that would require setback variances or something of that nature, would be able to do it as of right with a building permit. If your question is whether they have intention to, Ms. Doyle can answer that if she wishes to. She doesn't have to, but.
No, as a matter of fact, when we bought the original property.
Microphone.
We did not buy that second lot. And then the owner wanted to sell it separately, and he came in and he marked all the trees that they were gonna cut down to extend the driveway to that lot. And we said no. So we got the money and bought the other lot.
Just to prevent.
So at this point in time, anyway, it's not your intention to develop that lot? is that
Absolutely
correct?
not.
Yes, please. Grab the mic, please. Yep.
Hi, I have another question. It's related to easements. Our property has an easement, and we currently, the easement is like a river that leads up to my property. I'm part of it. And then it goes underground in an underground concrete tunnel. And up until recently, the township has been able to maintain that easement. However, I was recently told that they would no longer do that. I just wanted to know if that was true.
I think that's got to go through.
Yeah, I was going to say, I think you want to maybe raise that with the township committee. It's
Okay,
kinda
that's
beyond
the
our
correct
scope.
group. Okay.
But, good question. I think you should bring that
Okay,
to
thank
their
you.
attention.
Yeah.
I
Appreciate it.
think they meet tomorrow. Tomorrow, right here.
Sleeping in pews. Are there any other questions from the public? Then I'll close public comment and questions. So, Chris, if you wouldn't mind, could you just review kind of where we are, and then I'll open it up to the board for any last comments?
Absolutely, Mr. Chairman, but before I do, I'd just like to give an opportunity to applicant's counsel. Any summation, Fred, or you think?
I don't think
Good to
this
go.
needs a summation.
Yeah,
I think
just wanted to
everybody
make sure.
understands.
Just wanted to make sure.
Thank you very much for your time and
Of
patience.
course, absolutely. All right, so members of the board, before you is a minor subdivision application, AKA a lot line, a lot line adjustment, AKA a minor subdivision application. Applicants don't seek any variance relief on top of that, but however, they do seek a modification of a prior condition of a prior approval that created what is now lot 6.02. To the extent they want to modify that condition, they want it to modify it solely to permit this subdivision, not to excise that condition, meaning that they don't want to have that condition, which I should explain, prohibited further subdivision of lot 6.02. They don't want to get rid of that. They're okay with allowing that to continue, and but except they just want to modify it so that they can do this subdivision that's in front of you right now. So hopefully I'm explaining this the right way, but if not, let me know and I'll do my best to better do so. So that's really what's before you today to vote on. The conditions that the applicant stipulated to were contained in Mr. Voich's memo dated February 13, 2024. By my understanding, there were no other conditions in Ms. Lehenny's memo other than the removal of that shed, which we've kind of addressed and which doesn't need to be done because the applicants have indicated that it belongs to the adjacent property owner. And the only other additional condition would be just revising all the typos on the submitted plans if they weren't already spelled out in Mr. Voich's conditions. So that's it for the most part, unless I'm leaving anything out. Are the professionals think I'm missing anything? No? Good? Okay.
The only thing, just to be clear, it's
Yeah.
also lot 6 that wouldn't be further subdivided.
Oh, lot
That's
6.
the condition.
Okay.
6 and 6.
Okay. Okay, great. Thanks for clarifying those.
Yes, Mr. Sando?
It might be well to note in the resolution that this does not change any grade, any drainage. This is strictly a surveyor's tape subdivision, and nothing will be done on the ground to indicate that this has happened.
Good point.
I will make sure whatever resolution comes out of this, Mr. Sando reflects that.
Is that factual? Would they not put some kind of marker in that corner?
There'll be monumentation.
Okay,
With the exception of monumentation, there will be no further improvements to either.
thank you.
Well, that I have to object to because the board is not approving
As
any-
part of this
any
application.
improvements.
Right, right. As
But
part,
we're not prohibited unless there's
Right.
an ordinance prohibiting something.
no,
Okay.
I think Mr. Zelli, what Mr. Sando is what he's requesting is that it states in the resolution that this application before us doesn't involve any improvements. It involves
That's
purely
fine. That's absolutely
correcting
fine. Right.
the map. Okay, great. So that's it.
Great.
It would be a motion and a second. I'd understand any
I
motion to
would-
approve.
I would
to do
just
with all these
like to,
conditions.
one last question or comment for the resolution?
I'm
or-
ready to make a move, I'm ready to move the resolution.
Fantastic. Please make a motion.
I move that the board adopt the resolution as stated by our attorney.
All right, is there a second?
I second.
Excellent. Roll call, please.
Y'all caught me off guard over here. Mr. Sandow?
Yes.
Mr. Hands?
Yes.
Deputy Mayor Lavender?
Yes.
Ms. Dillon?
Yes.
Mr. Malinowski?
Yes.
Mr. O'Connell?
Yes.
Vice Chairman Jones?
Yes.
Chairman Richardson?
Yes.
It's gonna
We're
be in there
interchangeable.
for- Yeah. It's gonna be in there for a while.
I see the likeness.
Motion.
I feel honored to be confused with Mr. Sando, so.
I disagree.
Motion
That's
carries.
plagiarism.
We got there,
Thank you all
everybody?
very much. Have a wonderful evening.
Thank you, thank you.
Be careful out there, it's raining.
Okay, we got everybody. Let's make sure
Mis-
everybody.
Mr. Chair, can I interrupt? This has
Yes.
nothing to do with this application. I was
Please.
trying to find this, because a letter from Prism from a year ago, because this question came up, and I wanted to just be clear that there are provisions in the MLUL if there are sort of really outside factors that prevent a development from proceeding, then the tolling of time is suspended. And PRISM has maintained that that's the case. So I guess the question of, in 2 years, if they had to come back, they won't have to come back to get approval
Right.
for their application.
And that was the question of, is a
Yeah.
resolution necessary if there's a tolling of time?
Well, that's provided their argument would hold muster in court, that the time would be told. So I think out of an abundance of caution, that's why they've requested.
Well,
the extension, right.
exactly, but I
Right.
guess my point is I don't
Right.
want to either get people's hopes up or fears that they're going to come back before the planning board for an application.
Right, right.
Because
It was more-
They may not need
they
to.
most likely will not.
Right, it was more of a question of if somebody's reading this and isn't here, and they look at the application and they say, it tolls for 2 years, at the end of 2 years, I guess they can't develop anything, right? So it's more of the clarity that by issuing this resolution, do you make it so that the public is more confused by what's going on rather than just being silent and letting the tolling happen from what's already there? That was my point.
If I recall correctly, I think there's some language to the effect that they maintain the position that it's told, so that might kind of cover that basis. Hold on a second. Which one is this again, PRISM or?
PRISM.
This is PRISM, right? Hold on a second.
Yeah,
No, I mentioned this.
I
at
agree
some
with you,
point.
because I think people will come back and think that there might be another round, or they get another opportunity to say no, or they get to do this, and that kind of opens up Pandora's box, right?
Right, that was more of the point of, it's
Yeah.
already there, it's in place every single time you reopen it, you kind of, in a way, almost re-invite public opinion for something that
Yeah.
they don't really have an opinion on because it's told by the fact that they can't build.
Right.
Yeah.
And I will add to Liz's point too, that, and to what Chris had said earlier as well, the public is not generally knowledgeable of the procedures after the fact, after an application is approved. So we talk a lot about resolution compliance, but to
Right.
the public, they may not know what that is. So basically, once the boards have approved, just reiterating this for the public, maybe listening. And this is why I think, to Tony's point too, it gets very confusing with PRISM, especially when we have a moratorium and they're coming back to ask for extensions. The public doesn't understand that, behind the scenes, they got the approvals, great, but they haven't done anything since because they're not in a hurry right now.
Right.
There's no sewer. So until such time that sewer is available, and then I can guarantee you that it's gonna be like in our door, ready to go, wanting to get everything finalized. But the resolution compliance is the back end of the approval, once you have the resolution, remember, that our board professionals work with the applicant then to make sure that all of the conditions of the approval were met before construction even looks at that application for a construction permit, before a shovel goes in the ground. So there's still a lot to be done on the backside, but they're just not, they're a big developer. They don't have to hurry right now because
Well, they know they're up against a backstop with New Jersey American Water. And until New Jersey American Water submits the plans, an application, starts the process, builds out, ribbon cuts, makes it happen, and makes it productionized,
right. And
that PRISM's not gonna
technically,
happen.
I was under the impression, Chris, and correct me if I'm wrong, that because of the situation where there's a moratorium on development on any project in any town, technically, I thought that they didn't have to come back for the extension because by the MLUL standards, that tolling stops because of the moratorium. Now, in my opinion, in discussions we've had for PRISM,
It's arguable that it does. That's
Yes,
just it, yeah.
so just
Arguably, yeah.
just to do the right thing
Right.
legally, and so that the public of Long Hill all knows that PRISM is following, has their
Yep.
ducks in a row.
Yep.
It's definitely best for them to come back for the
Yep.
extension.
Agree.
But I guess my point is, it's not like in 2 years, if they don't do anything and the sewer's not extended, that they're coming back here with an application.
Right,
Yeah.
unless
But I
they get the sewer extended and they sit on their hands and they don't do anything, in which case they, then the
Well,
tolling period would no longer apply, right?
Right, but I think that it was maybe misrepresented
Right,
before, so I just wanted to
Understood,
clear that
yeah.
up, yeah.
Thank you. Okay.
We'll have that
I'd
topic.
like to move on to item number 10, the committee assignments. As we all know, we were very consumed with completing the master plan last year. This year, now the real work begins with regards to really executing, beginning to implement some of the actions necessary, especially through ordinance, I'm pleased to announce that Mr. Jones is going to take on and be our team committee captain for ordinance, and support from David Hands and Teresa Dill with regards to rounding out that particular committee. So thank you. On the standard operating procedures, this is something that had been initiated several years ago, I think even prior to COVID. I've approached Mr. Stando, who's graciously committed to steering us through to completion on that document that is fairly complete, but still needs some polish to complete that particular area. So that should come in fairly reasonably short order. The other areas are kind of the working groups associated with pre-application review, site plan review, and I've asked both Tony and Tom M. to take that on. Tom taking on really the chair, team captain of those two groups. We need to define better exactly some of the scope associated with those. I also asked our township committee representatives if they could be on hand to participate ad hoc on, depending on the application, and sit in on some of those meetings, because I think it's important for township representation to provide feedback in those areas. And that pretty much rounds out our committee assignments. The other area that I know Mr. Hands in the past, and we've done with various chairs, is work hard to have connections with our other township committees is very important. But it's reciprocal. We need to ensure that our time is well spent, especially communicating some of the recommendations out of our master plan to some of the various committees and commissions in town. We haven't made any particular assignments. I think I've approached various folks who make sense with regards to connecting with these groups because they're already connected. But we'll work behind the scenes to ensure that happens, especially in the first part of the year here, while the master plan is still fresh. Are there any questions with regards to some of the committee assignments? Again, I appreciate all of your attentiveness as I work behind the scenes to assemble these teams. I look forward to working with you on these.
Probably just one quick question. Is there any time frames that we should be aware of legally, or anything else that would focus our attention in one area versus another, do you think?
Not in terms of bulk standards of the zones, but perhaps maybe with stormwater. I don't know.
So, the most, well, it's actually, I believe it's covered. I'll double check our ordinance, but I believe because I've said this before, in prior applications last year, we have a citation-based stormwater control ordinance, the SCO. And what that does is it immediately takes effect with the adoption. So when the rules, the inland flood protection rules, were promulgated in July of last year, they immediately became effect for any major development. So that took the current year precipitation factors and added adjustment factors, as well as the future year 2100. Municipalities that have a standalone ordinance that's fully written out have to make changes to it by mid-July of this year. So that was kind of a gap in regulation that was afforded to us to determine when we wanted to implement that by ordinance, if we were in that condition. But we've already been proactive to say we want, when it relates to flooding and stormwater, we want the newest, greatest rules immediately.
So in a sense, the DEP rules automatically applied
Yes.
here? Okay.
Yeah, the FHA standard, the elevation of the height, is not really an issue at our level because it only affects state regulated permits as well as certain UCC requirements. So it's more construction code.
Right. Makes sense.
And then the stormwater side of that inland flood protection rule was there was a potential 1 year grace period
I see.
for ordinances to be adopted. So many other communities are going through that. We don't have to go through it.
You haven't said that still. Is that something we should focus on initially, do you think? Anything to
Well,
do
and I
with?
think, just to interject, what I'd like to do for time tonight is let the groups assemble and
Sure.
develop a set of priorities and a game plan. And I'd like the teams to come back and present that game plan with input from the board professionals too, behind the scenes, and hopefully keep this moving. So even really by the next meeting, if possible, present kind of the list of priorities. Yes, Mr. Sando?
I'd like to remind the ordinance people that back in late 2000, the ordinance committee began to tackle the problem of the development permit. Right now, our ordinance says that the boards have to approve the development permit unless there is no board action required, in which case the town engineer approves the development permit. Now, some of us felt at the time that the boards did not have the expertise to intelligently approve a development permit. All they could do was echo the recommendations of the engineers, and why bother? And so the intent of that effort was to change the ordinance dramatically in order to give the township engineer the final authority to approve the development permit, whether it goes to a board or not. And keep the boards working on the land use issues, not the water issues. Let the town engineer worry about that. There is no record that I'm aware of as to why the boards were given the authority in the first place to approve a development permit. Certainly is beyond the scope of their knowledge. And I would suggest that if you're going to do anything at all to conform to timelines, this would be a good time to shift the development permit in our ordinance to the sole responsibility of the township engineer.
Okay, I think
Yeah.
duly noted.
Yeah, noted. So any of those type of examples, I'll be looking to place into a tracker, and we'll start developing plans on how to address those and a host of others, as well as the recommendations that came out of the master plan. And working with the team and the professionals to construct a approach on how to systematically go through them. We may be able to bucket some things, we may be able to do one-offs, but we will look at that and put a priority against those
And I
as well.
think just the other exclamation point to put around the priority is the zoning map. Is working through and updating and starting with the map and the regulations for the zones.
Yep.
I think is critical.
Okay.
With regards
Noted.
to priorities, so. We look forward to the assistance from our able professionals. I please remind you on a lot of these non-applicant assignments especially. Please. Okay. Hello? Mr.
Dennis.
Yep. Dennis, yeah, come back. I just want to remind folks to please coordinate the request for professional assistance through me, just so we can establish some law and order and some fiscal responsibility for the town, especially for non-applicant, non-escrowed related projects.
Yep,
So
fine.
I would appreciate that. Thank you.
One
Yes.
oth- Yeah, the one other thing, maybe we think about it as a horizon item, but the next round of fair share housing is in 2025. So not that we need to action something today, but it's definitely something on the horizon
Yep.
that we're going to have to work towards.
Thank you.
Thank you.
Good.
Very good.
Any old or new business? Deb sent around an announcement for new member training course.
Or, well, it's,
So-
that
refresher.
particular course.
Refresher.
The bar, the Somerset Bar Association course is not just for new members.
Okay, yes,
Anyone can
but,
attend that one.
but for a new member, right, that's an opportunity, but you're right. Anybody can attend from a refresher. And how many spots do you have available, or?
Oh,
It's
open.
unlimited. Okay, perfect.
You just have to let me know by March 15th so I can pay for everybody and just let them know who's coming.
What was the
Right.
date again? It's a Saturday, wasn't it?
April 20th.
Okay, thank you.
April
It's
20th.
Saturday.
All right, do we get brownie points or any pat on the back for
Only if
going?
you go on your birthday. Just saying.
Tony.
College
Great.
campus on April 20th.
Non-compliant.
All right, I think we're at the hour. Do you have a motion, Mr. Vice Chair?
Yeah, motion to adjourn.
Second?
Second.
Thank you.
Thanks,
All
everyone.
in favor?
Aye.
Thank you all.
Well done.